International Business and Law Academy. I'm Ruby, and today we'll be discussing the theories of corporation law. First, let's dive into the case study of the parent liability for foreign subsidiaries and the law theory of piercing the corporate veil. That is the case of Union Carbide Corporation gas plant disaster in Bhopal. Facts. In 1984, industrial disaster from a chemical plant operated by Union Carbide India Limited (UCIL) into densely occupied parts of the city in Bhopal, India. The results were horrendous. Estimates of deaths range as high as 2,100 and over 200,000 people suffered injuries. UCIL was an Indian corporation, although 50.9% of its stock was owned by Union Carbide Corporation, a US corporation. The government of India owned or controlled another 22%, and UCIL manufactured the chemicals at Bhopal plant at the request of and with the approval of Indian government. India enacted legislation providing that the government, the Union of India (UOI), had the exclusive right to represent Indian plaintiffs in connection with the tragedy. The Union of India sued both the UCIL and UCC on behalf of all victims of the Bhopal disaster in a U.S. district court. The complaint against UCC was based on several notices. First, the UOI argued that multinational corporations are absolutely liable to the person and the country in which they have any manner caused to be undertaken any ultra-hazardous or inherently dangerous. Second, it alleged that because UCC knew the extreme danger posed by the chemicals activity stored at UCI's plant, its actions were deliberate, conscientious, and wanton disregard of the rights and safety of the citizens of India. And the third, UOI claimed the disaster was caused by negligence on part of UCC in originally contributing to the design of the plant and its provision for storage of excess amount of dangerous chemicals at the plant. Rather than addressing the specific to the UOI's complaint, UCC argued instead that the U.S. District Court should dismiss the claim because India, rather than the United States, was the appropriate forum for the lawsuit. Therefore, the issue here is, should the U.S. District Court dismiss the complaint because India is the more appropriate forum? We would like to invite all of you to discuss this together. Please start us off, Turan.
Under generally accepted theories of the corporation law, a parent corporation is not liable for the debts of its subsidiaries. So the parent's losses are limited to the amount it has invested in the subsidiary. UCIL was an Indian corporation, although 50.9% of its stocks was owned by the Union Carbide Corporation as a U.S. corporation. So we need to keep in mind that the concept of a foreign invest company and the concept of a limited liability company.
That's good. Ms. Nguyen, would you like to add?
However, courts may piercing the corporate veils and strips away this limited liability when a subsidiary is not adequately capitalized to meet the accepted claim that may arise against it. The Union of India sued both UCIL and UCC on behalf of all victims of the Bhopal disaster in U.S. District Court because the industrial disaster from the chemical plants were horrendous. Estimated deaths range as high as 2,100. Over 200,000 people suffered injuries.
Yeah. And would you like to add to Ms. Nguyen?
Well, this is even more likely to occur in tort cases where the parent effectively controls the operating decisions of the subsidiary and where the subsidiary was established to carry out inherently dangerous activities in a foreign country. I agree with Union of India, who argued that multinational corporations are absolutely liable to the persons and countries in which they have in a manner caused to be undertaken any ultra hazardous or inherently dangerous.
But John, is any a parent company also held responsible for any of this? I
I
mean,
believe
can
so.
they?
Yeah. For the torts of its foreign subsidiaries and the theory of direct liability. So when the parent fails to intervene and supervise the operation of the subsidiary, right? So in this case, the evidence shows that UCC knew of the extreme danger possessed by the chemical activities stored at UCI's plant. Its actions were in deliberate, conscious, and wanton disregard of the rights and safety of the citizen of India.
Thank you for your comments. Now, what is a direct liability? And so, what evidence is there for an American court to judge UCIL, an Indian corporation? Please, Ms. Wan.
I think this trial should be tried in India courts because the company operated in India. Union Carbide Corporation, a U.S. multinational corporation that's invested in India, is legally responsible for an accident that caused a fatal incident.
That's true. Turin?
The tort of agency theory of the direct liability court imposed this special duty of parents when a subsidiary is dealing with a hazard activities, particularly when the subsidiary is doing business in an undeveloped country that lack the technology needed to protect against the potential harm.
And Anne?
Well, according to the evidence, that shows that the UOI controls the terms of the agreement and precluded the UCC from exercising any authority to detail, design, and erect and commission the plant. The vital parts of both power plants, including its storage tank, monitoring instrumentation, and vent gas scrubber, were manufactured in India by Indians.
Although some 40 UCIO employees were giving safety trainings at UCC plants in the United States, they represent a small fraction of the Bhopal plant's employees. Further, India has a stronger countervailing interest in educating the claims rather than in its court according to its standards rather than having Americans' value and standards of care imposed onto it.
Yeah, that is absolutely correct. And thank you again for discussing the case and explaining the theoretical explanations very well. Now I'm going to talk about the final decision of the case. Should the US District Court dismiss the complaint because India is the more appropriate forum? The decision here is yes. The private interests of the party weighs heavily on the favor of litigating this matter in India. The many witnesses and sources of proof are almost entirely located in India, where the accident occurred and could not be completed to appear for a trial in the US. The Bhopal plant at the time of the accident was operated by 193 Indian nationals, and great majority of these documents bearing on the design, safety, startup, and operation, as well as safety trainings, are all located in India. And India's interest is increased by the fact that it has for years treated the UCIL as an Indian national, subjecting it to intensive regulations and governmental provisions for constructions, development, and operations in Bhopal plant. Moreover, in view of India's strong interest and its greater contact with the plant, its operations, employees, and the victims of the accident, the law of India, as the place where the wrong occurred, will undoubtedly be governed there. And in contrast, the US interests are relatively minor. Thank you so much. As we have discussed the Union Carbide Corporation gas plant disaster at Bhopal, you all should have a clear clarification about the theories of corporate law. Therefore, I would like to give my thanks to the International Business Law and especially Dr. Sung.